You're married, and you're assuming the wedding erased your overstay or unauthorized work. You entered on a visitor visa, you married quickly, maybe picked up a job, and now you're staring at a stack of immigration forms wondering if you can just file and fix it. File these blindly and you can trigger a 3 or 10-year bar. You can get flagged for misrepresentation or even face a lifetime block on future marriage petitions, none of which marriage cancels. Hi, I'm immigration attorney Zaira Solano with over 13 years of experience in immigration law, and today I'll show you exactly who can still adjust when married to a U.S. citizen and why that forgiveness doesn't apply if your spouse is only a permanent resident, when you must not leave the United States, how to handle the 90-day scrutiny at an interview, and the evidence that actually proves a real household. So let's jump right in. One of the biggest traps is assuming that marriage wipes away every past mistake. It simply does not. The good news is that immediate relatives of United States citizens, including spouses, can adjust status here in the United States despite unauthorized work or a visa overstay. That forgiveness exists in the law, but it does not apply if your petitioner is only a permanent resident. Know exactly whose rules you are playing under before you file your application with immigration. Entry and travel create the next set of hazards. If you entered as a visitor and married quickly, officers may test whether you intended to immigrate when you came into the United States. Many follow the 90-day guideline when they assess intent. Marrying or filing soon after arrival to the United States is not an automatic denial, but you should expect pointed questions about timing and purpose. Tell the truth. Explain how plans evolved after you entered the United States. Unlawful presence and departure is the landmine couples miss the most. Leaving the United States after more than 6 months of unlawful presence can trigger a 3-year bar. If you stay here for more than a year and then depart, it triggers a 10-year bar. That is under INA Section 212A9B. Marriage does not cancel those 3 and 10-year bars. If you're adjusting status, the safest move is to remain here until you have a green card or, at a minimum, advance parole in hand. There is a narrow exception worth knowing, and it's one of my favorite tools in my immigration toolbox. In matter Arabali and Yarabelli, the Immigration Board of Appeals held that a departure on advance parole during a pending adjustment of status did not count as a departure for the 3 and 10-year bar. That decision is technical and fact-specific. Do not test it without legal representation. Finally, never minimize misrepresentation. If you have ever lied to obtain a visa or admission into the United States, even a small lie, you can be found inadmissible under Section 212A6C. That requires a difficult waiver built on proving extreme hardship to a qualifying relative. A forgiven overstay is one thing. A fraud finding is quite another. Be completely candid on your forms and at the interview and build your case around the law that helps you rather than hoping no one will notice what hurts you. When in doubt, slow down, read the USCIS policy manual instructions line by line like we do, and get advice. A careful start prevents denials. It prevents second interviews and years of separation that no couple intends to risk. Think of the interviewer as a professional conversation where your everyday life is the subject. Officers compare answers, documents, and demeanor. The most common pitfall is inconsistent answers between spouses on basic facts. You do not need a script. You do need share recall. Review the timeline of your relationship, how you divide the day, holidays with each family, bills, and key dates. Small gaffes are normal, but big contradictions look like fabrication. Documents matter just as much. Walk in with originals and updated proof that you live as a household. When I say updated, I mean proof that you obtained after you filed your applications. Some of that evidence includes recent joint bank statements, lease or mortgage pages, insurance, utilities, tax transcripts, photos, and mail to the same address. Disorganization prompts requests for evidence from Homeland Security, and undermines credibility. An orderly binder signals care, and care reads as truth. Your demeanor counts. It's easy to get defensive or sarcastic when questions feel personal. You gotta stay calm, answer directly, and treat the officer with respect. Arguments between spouses in the room suggest a relationship in trouble. Identical memorized answers suggest coaching. Authentic couples sound natural. And if you don't know an answer, say so and clarify later rather than guessing. Some cases are more likely to draw intensive review even before the first question. Common red flags include a significant age gap, no shared language, big differences in culture or religion, a whirlwind courtship, or a marriage timed against an immigration deadline. None of these are fatal, but each one demands stronger, earlier evidence and clear explanation of how your life works. Prior marital or immigration history raises the stakes. If the petitioner has sponsored a spouse before, expect detailed questions. If the beneficiary previously pursued a fiancé or marriage case, have full files ready and be prepared to explain what happened and when. Missing divorce decrees or overlapping timelines are a classic reason I see for denials. Living apart after getting married requires special care. Long distance for work or school is possible, but you must document travel, communication, and plans to reunite. Secret or barely announced marriages draw the same skepticism. Explain sincerely and show affidavits from people who know you as a couple. And here's one final warning. A government finding that a marriage was entered to evade immigration laws trigger INA Section 204C. That bar blocks future immigration petitions for life. Build your case to avoid doubt, not to survive it. Preparation wins. The Affidavit of Support, Form I-864, is not a box to check. It is a contract. The sponsor must show income or assets at 125% of the federal poverty guidelines for the household. Count everyone correctly, including the intending immigrant, dependent children, and any immigrants previously sponsored. If income is short, line up a joint sponsor or document assets that reach the threshold. Each sponsor must independently meet the full requirement for the intending immigrant. You cannot simply add unrelated incomes. Prove domicile in the United States if the sponsor has been living abroad. Attach tax transcripts, W-2s, pay stubs, employment letters, and proof of assets. The sponsor's obligation lasts until the immigrant becomes a citizen or another terminating event, and it is enforceable in court. Treat it with respect. Paperwork rules evolve. In 2025, USCIS issued new editions of key forms. Mailing an old edition or skipping a required page can trigger a lockbox rejection. Always download forms from the USCIS website and confirm the edition date. Translate every non-English document with a translator certification. Use the latest poverty guideline chart when you complete the I-864. Answer every question honestly and completely. Respond to any request for evidence quickly. Update your address within 10 days of any move so you do not miss notices or interview letters. Submit a sealed medical exam on Form I-693 and make sure you ask the doctor to provide you a separate unsealed copy so that you can review it and assure everything is correct. Also, on the medical exam, make sure that your doctor and yourself signed it before you send it into Homeland Security. Travel and status history matter. Unlawful presence followed by a departure can trigger a 3-year or 10-year bar under INA Section 212A9B. Marriage does not cancel bars. Advanced parole while adjusting protects reentry, but do not travel without legal advice. If you have a prior removal deportation order or voluntary departure, you might need to reopen that case or obtain permission to reapply before adjusting. Criminal issues can be decisive. Many crimes involving moral turpitude require a waiver that proves extreme hardship to a qualifying relative. Drug offenses are treated more harshly. A single conviction of possession of a controlled substance other than a small amount of marijuana can block a green card with no waiver available. Expungements and diversion count as convictions for immigration purposes. Disclose arrests and submit certified court records. For petitioners, the Adam Walsh Act bars sponsorship for offenses against minors. Plan around these realities before you file. Conditional residence catches many couples by surprise. If your marriage was under 2 years old on the day your green card was approved, the green card you receive is conditional and only valid for 2 years. Before it expires, you must file Form I-751 to remove conditions, filing jointly in the 90-day window before your green card expires. There is no grace period. If you fail to file timely before your green card expires, your legal status ends the day the card expires, and you may be placed in removal proceedings. Put the expiration date on your calendar and start gathering evidence in advance. Treat the I-751 as part 2 of proving a real marriage. By then, you should have stronger proof of a shared life together. Submit joint tax returns, updated bank statements, insurance, leases or mortgage records, new photos, and affidavits from people who know you together. The burden is on you to show that your marriage is or was genuine and not a device to obtain an immigration benefit. Divorce for separation in this period is not the end, but it changes your path. So if the marriage ends in divorce, you can request a waiver of joint filing and file your I-751 alone, proving that the marriage was entered in good faith. Be candid about the timeline and provide proof of your shared life while it lasted. If abuse for extreme cruelty occurred, you can seek a waiver under VAWA and file independently without the abuser. If you are separated but not divorced when the deadline approaches, strategy matters. Some file jointly if reconciliation is likely. Others wait for a decree and file a waiver. Choose truth and get advice from an immigration attorney as you pick your path. Do not ignore the conditional stage. Failing to file or appearing at an interview as an estranged couple can lead to denial and placement in removal proceedings. Treat a removal of conditions application like a second green card process, and you will avoid most pitfalls. Here's the summary. We covered adjustment of status rules, travel risks, misrepresentation, interview red flags, financial sponsorship, paperwork hazards, and the I-751 conditional green card timeline. Now you know where couples stumble and how to prepare with honesty, records, and calm. Now do me a favor and press the like button if you found this video helpful. And whatever you do, don't miss my next video, Deportation Risks for Green Card Holders in 2025. It explains how new residents lose status through crimes, abandoned residence, trip, and the avoidable mistakes. If you want to protect what you have earned, this guidance is vital. See you over there.